I'm going to talk today about procedure for first appearance in the Magistrates Court for summary-only offences. So just to define what I mean, summary-only offences are allegations of offences that can only be heard in the Magistrates Court. They cannot go to the Crown Court, they cannot be sent to the Crown Court, the defendant cannot elect to go to the Crown Court. These would be matters such as, for example, common assault, assault by beating, such as low-level criminal damage, such as TWOC, taking without consent, and even matters such as aggravated vehicle taking, where the value of the alleged damage is low. So these are matters that can only be heard by the Magistrates Court and can only be sentenced by the Magistrates Court if the defendant is either going to plead guilty or is subsequently found guilty at trial. So the procedure. The first point to consider is how the defendant has arrived at court. Have they been brought to court by the police, so the police have refused bail, or have they been charged and bailed to court by a custody sergeant, or have they received a requisition or summons in the post? This is important because if the defendant has been brought to court or has been bailed to court, then they physically have to be present at court, otherwise there is a risk that the magistrates will issue a bench warrant for their arrest. However, if the defendant has received a requisition or a summons in the post, then it may be that under the Magistrates Court Act 1980, they do not have to attend in person, provided that they send a lawyer on their behalf. Either way, the first matter to address will be a plea, whether the defendant is going to plead guilty or not guilty. Now, prior to the first hearing, if there has been time, so provided, for example, that the individual is on bail from the police or has received a requisition, it should be possible to have requested and received from the prosecution some papers relating to the allegation. Those papers should normally include the charge, the matter that is actually alleged, the bail position, possibly some witness statements, or at least a summary of witness statements, and also a summary of what may have been said in interview under caution, together with, if there are any, antecedents. That's the criminal record of the defendant, if there is any. The defendant will then need to decide whether they're going to plead guilty or not guilty, and if they plead guilty, whether that is on any form of basis of plea. But assuming they plead guilty, the matter would normally proceed to sentence either on the day, or it will be adjourned for sentence, normally in order for the probation service to prepare a pre-sentence report. If, however, the defendant pleads not guilty, the matter will nearly always be adjourned to a future date for trial. And if a not guilty plea is entered, it will normally be necessary to complete documentation relating to preparation for effective trial. That's known as a PET form, preparation for effective trial. The preparation for effective trial form sets out those matters that the court needs to know in order to assign sufficient time in the court diary for the trial to be heard. So, for example, the parties, the prosecution and the defence, will need to set out how many witnesses they wish either to call themselves or to be called for cross-examination. So, for example, if this is a case involving police witnesses, it might be that some of those police witnesses can be agreed, their statements can be read out as a Section 9 statement. However, if the matter that they say is in dispute, so if the evidence that they give is contested, it may be necessary for them to come to court in person in order to be cross-examined by the defence. Likewise, there may be defence witnesses that the defence want to call, in which case it may be necessary for them to be identified, for their names to be given, addresses to be given, dates of birth, that to be given, so that the police or the prosecution can, if necessary, decide whether they wish to speak with the defence witnesses in advance. The PET form will also provide details of what is in dispute and also perhaps what is not in dispute. So, for example, it might be that a defendant accused of, for example, common assault, it might be that the defendant accepts that they pushed or punched or otherwise touched the alleged victim, but might wish to raise the issue of self-defence. If that's the case, it might be appropriate to put that information on the PET form in advance so that the court can allocate the appropriate time and resources of the court service for the trial. So to recap, at the first hearing in the Magistrates Court, depending upon how the matter arrives in court, it will either be the defendant is brought to court in custody by the police, or they have been charged and bailed to the court, or they have received a requisition. Once at court, the first matter to address will normally be a plea, whether it's a guilty plea or not guilty plea. If it's a guilty plea, the matter will either proceed to sentence, or it will be adjourned for a pre-sentence report in order for sentence to be passed on a subsequent occasion, or the matter will be prepared for trial. Preparation for effective trial form will be completed. The last thing that the court will then want to address is the question of bail. If the defendant has attended on bail, whether that bail should be extended, and if so, with what conditions. And of course, that's where the matter concerning the Magistrates Court Act for defendants who have appeared by way of requisition is quite important, because if the defendant has received a requisition in the post and sends their lawyer on their behalf, then under the Magistrates Court Act 1980, the lawyer can attend and, for example, can enter a not guilty plea on their behalf and prepare the matter for trial on their behalf. But if the defendant is not present in court, then the court is not able to impose bail conditions. This can be important because if bail conditions are not imposed, then if, for example, in the meantime, the defendant is suspected of committing a further offence, then that further offence is not made more serious by the fact that they were on bail at the time. So it may be appropriate for defendants who are appearing in court by requisition not to attend in person, but to send their lawyer on their behalf.